Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Mazzucci.
Welcome everybody to the show. Thank you for joining us today. We are talking to Kim Millman, who is an estate planning attorney who focuses on estate planning, trust administration, charitable planning and giving, as well as business succession planning. Kim, thank you so much for joining the show.
Thank you for having me.
So one of the things that I've noticed is that there's a lot of estate planning attorneys who just do the trust and then forget about it. But you talk about trust administration, which is you don't leave people in the dark. Can you tell us what is trust administration?
That's a great question because there's a lot of misconceptions about this. People who do estate planning, whether they do it with an attorney or they do some sort of online type thing, they think that if you do a trust, when someone passes away, you don't have to do anything. But the way I like to explain it is trusts are not magic. They don't do anything. They are documents that tell people what to do. The person that they're telling what to do is the successor trustee.
Right.
So if the document says that the assets get split between a decedent's trust and a survivor's trust, which is what usually happens when the first member of a couple dies, it doesn't automatically happen. Somebody has to do it. If there's a tax return that needs to be filed or an estate tax return that needs to be filed, assets need to be valued, the documents need to be read, the successor trustee needs to actually be appointed. Just because the document says, I nominate Joe to be my successor trustee, it's not automatic. So there is this huge misconception that you don't need to do something when someone passes away.
Yeah.
And that's not true. And I've had people come to me as recently as somebody passed away a couple of hours ago to as long as 20 years ago to do a trust administration that needs to be done. When I do an estate plan with somebody, I tell them, this is just step one. When someone passes away, you got to get to step two. But I have discovered that not all attorneys tell the clients that, or they don't hear that. But it is a critical thing to do. And the most important thing to understand about trust administration is there are rules and guidelines, both from the state of California and the federal government, that have timelines associated with them. You need to do things within certain time periods. And if you have a happy family and nobody's fighting with each other, then I suppose if you miss your deadlines, it's not a big deal. But if you have beneficiaries that don't get along, or trustees and beneficiaries that don't get along, it can turn ugly. So trust administration is a critical thing that a lot of people miss. And there's a lot of really screwy stories that come out of that.
Absolutely. And if you spend any time in probate court, you'll know what I mean. Some of these days are like a Jerry Springer episode when I go to for confirmations of sales. Seriously, like I heard people say, Dad didn't love you as much as they loved me, blah, blah, and things like that. So obviously there is a need for this trust administration, which is somehow forgotten. And you're absolutely right, Kim. I mean, you're absolutely right. People do a trust and they think, I have a trust. What do I have to worry about? And I've seen when it comes to the side of selling that, an affidavit of death is not being filed. So, the title is still in the people past 20 years, maybe it's past time, one of the spouses is passed. And so how do you help your clients stay on top of these milestones that happen during the lifetime of an individual and beyond?
So there's two parts to that. So on the trust planning side, as I mentioned, I tell the people in advance. And the first page of my documents in bold print, it says, this is a document that tells people what to do. If something happens, somebody dies, somebody becomes incapacitated, you must reach out to me or another attorney and start the process of what needs to be done. Right. I tell them this and I write in the documents. Now, the reality is the person I'm telling that to may in fact be the person who passes away. Right. So I'm optimistic that the successor trustee or family member will see that and pay attention to it. Okay. I also tell my clients, do not lock up their trust documents. Don't put them in a safe deposit box. Don't put them in a home safe. Very good advice. Because if someone dies and nobody knows where the documents are, they're as good as not existing. So that's one way I try to take care of it. On the situations where I'm doing a trust administration where I didn't draft the plan and that somebody has come to me after someone's passed away and I'm looking at some other attorney's documents, I'm very detail oriented and very methodical in the way I do things. So I'm constantly on communication with the trustees and making sure they understand why they have to do what they have to do and what the steps are and what's required. And I don't really let anything just sort of happen by chance, much as I can possibly prevent that, because unfortunately the trustee has ultimate responsibility and liability. Right. So it's, as I describe it to the clients, it's my job to make sure that you do it right. So that's the goal. The other thing I think it's a really big deal that you have to have the beneficiaries need to have an understanding of what really is involved, because an average trust administration takes between 9 and 18 months, assuming nothing weird, assuming the assets are understandable and you can either keep them or sell them or value them and get them all valued, all those things. Between the statutory timelines and just putting all the pieces together, 9 to 18 months is pretty standard. Beneficiaries don't understand that. They, as I like to describe it, grandma died, where's my stuff? Right. And unfortunately, that puts pressure on the trustee to try to have to, field those inquiries from the beneficiaries. And to the extent that I can talk to the beneficiaries, because I don't represent them, I can only give them general information, is, these things take time. If you have questions and I can answer them, I'm happy to answer them. If you have questions and I can't answer, you may want to get your own attorney to give you an example or explanation rather of how the process works. Right. But again, there are steps that need to be taken and notifications that need to be given. And each one of those carries a timeline that goes with it to give people an opportunity to be heard or object. And you just got to work your way through the process. And depending on what the asset mix is, it can be a complicated process. The other thing I probably want to throw into this is on the planning side, I do everything I can. I'm not always successful at this, but I try to get my clients to simplify and consolidate what they have, because nothing makes beneficiaries more upset than when they have to deal with lots and lots of things in teeny tiny amounts that they can't figure out. I had one client who, unfortunately, I did an emergency plan for her because she was on hospice. She was perfectly fine mentally. She's a wonderful woman, very, very bright. But we didn't have a lot of time to examine everything. And she swore to me, it was a redo of an existing trust. So that the trust already existed by name. So we did a restatement and she swore to me that everything was already in the trust. And I said, great, I take your word for it. She passed away a couple of months later. Her husband comes back to me. He thinks everything's good to go. We had just redone everything. Well, it turns out she had like 27 bank accounts, which I did not know about. And he's like complaining that what do we have to do with all this? Well, I'm really sorry. I had no idea. They were all in the trust, which was good, but still consolidating and dealing and valuing and closing 27. It's a lot. So to the extent that people can get rid of all these little tiny accounts all over the place and try to consolidate as much as possible, it makes it easier for them, especially as they age, and it makes it a lot easier for the trust administration process.
That makes total sense.
Because all those random little assets it takes just as much time to deal with and close out a big account than a small account.
Yeah. So for anybody who's watching this, if you have a trust, talk to your successor trustee. Don't make it a secret, hide the trust somewhere, and then hopefully some days, not all successor trustees may know that they are successor trustees. I mean, I've seen things like that as well. So in your case, Kim, are you nominated as a successor trustee when you do the trust administration?
So the drafting attorney is not really allowed to be the trustee, and I would not want to be the trustee. Okay. The trustee, there's a couple of different ways that make good trustees. There's a lot of people like to have friends and family become the successor trustees. I am not a big fan of that because being a trustee is a really hard, difficult, very high liability job. And if you don't know what you're doing, the chances of doing it wrong is really high. And if you do it wrong and the beneficiary is unhappy, you could be personally sued. So people have this idea that, well, I'm going to make my oldest child the successor trustee because it's an honor, or they'll be insulted, or all of these other reasons. And the real answer is that's not the reality. I tell people, if somebody asks you to be a trustee, you say no, because it's really a lot of work, and people
That's
have
why we
no
have
idea.
professional fiduciaries, right?
Exactly. So the options are either a private professional fiduciary, which sometimes works, sometimes it doesn't. If the person creating the trust is too young, then you don't want to use a private professional fiduciary because you don't know how long it'll be before they'll. But there's large banks, there's small banks, there's institutional trustees. So those all work. You can have a trustee. I mean, I oftentimes have family members or friends as trustees, but there are people who are likely to be successful in the job. There are CPA, friends that are lawyers, or friends that are CPAs, or friends that are something to do with, they understand what's required. To be a trustee, you have to be good with money, understand legal documents, understand financial statements, and take the instructions that you're given from, whether it's from the CPA or from the attorney, because these things have to be done. And there is a huge misconception. And somebody who doesn't have that skill set, it's just a recipe for failure. And then, of course, everybody's unhappy.
Yeah. So Kim, if you do the estate planning and somebody says, look, I don't want to have my kids to be the trustee and I don't really know anybody, you're also able to recommend, as you mentioned, institutions or individuals that can do the job professionally and efficiently.
Correct. Yeah, I know several in all different categories. Like I said, if the client already has a relationship with some kind of institution, my first choice is almost always going to be where they already have that relationship. If their bank or investment advisor is connected to they have a trust department, that's the easiest, because then the assets are not going to have to be moved all over the place. Not all institutions have that. Not all people have a relationship that's already existing. So in those cases, then we go looking for who else is a good fit. And like I said, I like private professional fiduciaries because they're more hands-on than maybe the big institutions. But unless you have a situation where you know what the timeline is, it's more likely that an institution is a better choice. And then the other thing that comes into play when you start looking at who could be the trustee is you have to look at what the assets are. Because if the person has just, say, investment accounts, stocks and bonds type things, then the large banks and stuff will take them. If they have a more eclectic mix, they have real estate, they have apartment buildings, they have a sole proprietor business, large institutions won't take them. So that's when you get the best choice for people like that is something like a community bank that's far more flexible with what they'll take on. Because remember, when the person's gone, the trustee gets to pick up all of those assets under their control. And
there's liability with picking up those assets, as we see it, especially like in the example of, like you said, when apartment buildings are an example of things where, you become a landlord essentially. And not everybody wants to take that kind of responsibility on.
Exactly. So, and I've come across some institutional trustees that they have, and when this happens, I can't work with them because they're willing to be the successor trustee, but they will only become successor trustee over their assets under management. And I go, well, what are we going to do with the house? Well, then you have to have a different trustee. I'm going, well, what do I need that for? I mean, that's just not functional. You can't be so tiny there. It's just not going to work.
Yeah, that makes total sense. Very good. This has been, it's extremely informative, and I appreciate you sharing your knowledge with us. I wanted to touch upon something else that you do as well, which is charitable planning. A lot of our listeners, I think, would be very interested in that. How do you approach, when somebody comes to you and they say, Kim, I have certain assets that, I want to go to charity, or sometimes I've actually had sold properties where everything goes to charity. I just sold the St. Jude something where the trustee was St. Jude's Children's Hospital. So how do you help somebody who has a philanthropic
approach? That's a very interesting thing. So charitable planning really has two functions. The number one function is to fulfill the goals of somebody who really is philanthropically inclined. That's not always the case. There are some people who there are far less people who are philanthropically inclined than those that are.
Okay.
So if somebody is truly that they want to do part of their estate planning as a charitable component, there's several ways to do that. You can do it as an outright gift, or you could do it at some kind of more complicated trust plan, which I'll explain in a minute. The other thing is there are people who are likely to pay estate taxes. And one way to reduce estate taxes is through charitable planning.
Mm-hmm.
On the surface, you would think, well, if somebody doesn't want to pay estate taxes and they're willing to pay it to a charity, they're more likely to do that. But even that doesn't always work. So ultimately, even in a situation where you're mostly doing it for estate planning purposes, for estate tax purposes, they still need to have a philanthropic component in their mindset. So in terms of how you can actually do it, well, when you give it a distribution plan as part of an estate plan, there's two parts to it. There's what are called specific gifts, and then there's what's called the residuary.
Okay.
The specific gifts are the thing, I want to give this thing to this person.
Yes.
The residuary says, I want to give everything else to my kids or my whatever. If you wanted to give specific gift to a charity, let's say I want to give, $10,000 to each of these 3 or 4 things, you could put that in your trust as a specific gift. The thing to understand about specific gifts is they come off the top. They're the first things paid. So if you have an estate worth $500,000 and you give $600,000 in specific gifts, you're not going to make all your specific gifts, and whoever's on the back end doesn't get anything.
We'll get nothing.
So you got to check your math on how that's going to work. And again, you do the plan for something in the future. So you want to be careful with how you do specific gifts.
Right.
And so that is one way to do charity. And that's very common. And that's usually done for smaller amounts to specific things. And you can set that up to be done after the first spouse dies or after both spouses die. So that's the easiest one to do. Another thing you can do is you can set it up so that at the death of whether the first or the second person, some percentage of the estate goes to a charitable portion of the trust. It could be all of it, or it could be, half to charity, half to my kids. You can do as many charities as you want. And you could just say half of the estate goes to this many charities. And at the end of the calculations of what everything's worth, you figure out how much goes to each place. In general, it's easier to give charities fixed dollar amounts than percentages because it takes a lot longer to figure out percentages, and there can be a dispute as to what something's valued at.
Right.
So most of the time when we're doing that kind of planning, I'll say, okay, let's pick a dollar amount. We're going to give, $500,000 to charities and the rest to wherever it's going to go to, and we'll just do it that way. So that's one way of doing charitable planning. Then the third way, which is probably the most complicated, is to do what's called some kind of charitable trust. When there is either a charitable lead trust or a charitable remainder trust, the difference is who and when the money goes out. But essentially the way that works is you put X amount of dollars into a special kind of trust. The charity gets paid some amount of money for so many years, and then what's left over goes back to the beneficiaries, or the reverse of that. The beneficiaries get paid for some amount of years, and then at the end goes to the charity. The advantage to that type of planning is it creates a delayed distribution scheme for for who's ever on the other half of that equation. And there are rules on how you can do that and how much has to be paid out and what the interest rate can be. So those become more complicated and more difficult to figure out. But if somebody's trying to, play it in all directions, have some amount go to charity, have some amount go to their kids, have some amount come, 20 years down the line, that's part of what you can do. And
Wonderful.
Again, all of those options work great for estate tax planning or just for charitable planning in general. There's another type of charitable planning that has to do with people when they're alive. They wouldn't give it away now. That becomes an income tax type of deduction. I don't generally do those. I really more focus on testamentary planning and what happens with people after they pass away.
Thank you. This is very informative. Very, very good. Now let's talk a little bit about you. Okay, so law is your second career. I have a huge forgive me, I have a huge admiration for adults who go to law school. I don't know why, but maybe that's where my future is headed, but I can tell you that. But how did it start? Like, let's talk. What did you do before you became?
So my family started a business when I was a child.
Okay.
And the business was in the fashion industry. And My father was a child of an entrepreneurial family, and my father really believed that everything, entrepreneurs are the best type of business owners at getting and doing that. So I have one sister, and basically from the time we were children, we were raised to be business owners.
Wow.
And the business that we had, like I mentioned, was in the fashion industry, and my mother was the fashion side of it, and my father was the business side of it. And my sister was trained to be my mother's replacement, and I was trained to be my father's replacement.
Wow.
So I really was doing, I am not kidding, I started working when I was 10.
Wow.
So I worked full-time in junior high, full-time in high school, full-time in college. My life was pretty much controlled by the family business. And the family, we had multiple versions of it over the years, depending on what was happening with the economy. But we were something called a jobber, which is basic, doesn't exist anymore, but jobbers bought product from manufacturers, broke them into small lots and sold them to individual stores.
Okay.
Over the years, the individual stores all went away, so those didn't exist anymore. So then we became domestic manufacturers, and we made stuff for the stores, and it was all private label. So if we made it for Nordstrom's, it said Nordstrom's. If we made it for Macy's, it said Macy's. Eventually, that became unfunctional or non-functional because domestic manufacturing was too expensive. So then we became importers. We had everything made overseas. And throughout that entire time, we were selling to retail stores. Also, during that time period where things were sort of changing and evolving, my father unfortunately passed away very young, very suddenly. He was 45, I was 23.
Oh, wow.
And I was all of a sudden running the business side of the business.
Oh, wow.
That was actually my first experience with this, what happens when you don't have an estate plan, because my father died, like I said, very suddenly, very young. So he didn't have one. As a matter of fact, on his desk was a little Post-it. Well, they didn't have Post-it notes back then, but a little paper that said, make a will, which of course didn't happen. Over the years, as we sort of morphed with the times for the economy, and eventually what we ended up doing was we started a mail order catalog. And we did that we had a company that we were selling to that was a mail order catalog, and we decided that we can go into competition with them. So since we were private label, we just took all the product that we had been manufacturing for other stores. We hired a graphic artist. We designed a brand, which was called Girlfriends LA. We ran a full page ad in 17 magazine that said you could either buy the product or you could request a catalog. Wow. The day the ad hit, we got 6,000 phone calls.
Wow.
Which we had, at the time, we had 7 lines and 7 employees. So 6,000 phone calls, complete disaster. I mean, a complete disaster. So we ramped up really quickly. We ended up running Girlfriends LA for just about 6 years. At the time, we ended up selling it to a conglomerate that ended up closing it down, but they did run it for a short period of time after they bought it from us. At the time we sold it, we had 250 employees. We were producing 30 million catalogs a year. Wow. And we had a database of about 8.5 million teenage girls. Amazing. And what's really funny, and we sold it, almost 20 years, well, more than 20 years ago, actually. It's 2002. And to this day, if you Google Girlfriends LA, there are fan sites to Girlfriends LA. All these years later, it is awesome. It is really awesome. And part of what made Girlfriends LA special is Girlfriends LA had a mentality. We were completely vertically integrated. We did everything. We designed the fabric, we designed the clothing, we designed the catalog.
Wow.
We had an in-house call center, an in-house distribution center. We could, turn on a dime to respond to customer requests. And one of the things that we learned was that this was a long time ago, and models were like reed thin, and clothing came in small sizes only. So we started doing larger size models and larger size clothing. Oh. And so there were girls who said, they were so excited with our product.
So you were a pioneer in that space, because now it's given for granted, but 20 years ago, it certainly wasn't.
Correct. So when we sold the company, I decided, I had always been doing the business and finance and tax planning and projection side of the business. So I had wanted to go to law school when I was younger, but I never did because I got sucked into the family business. Right. So once we sold GFLA, I went to law school.
Wow.
And while I was in law school, I determined that the best place for me to exist is in the estate planning and estate administration side of things. I had learned through enough very unfortunate litigation experiences with girlfriends that I never wanted to be in a courtroom. So, which is why my practice to this day does not have anything to do with the courtroom.
Right.
And part of running a company is tax planning and forecasting, and part of estate planning is tax planning and forecasting.
Right.
And because I was an entrepreneur for so long, I understand what it's like to run a business. And to a very small extent, being a trustee is like being in charge of a very small business that you're trying to, get all the documentation put together, get all the tax return filed, and get your product out, which is really, the money to the beneficiaries. So it's a great fit for me. And I have to say, I really love what I do. I love working with my clients. I love helping families. It's a lot easier to be a lawyer than it is to be in the fashion industry. I would tell you that.
Oh, interesting.
The fashion industry is really cutthroat.
Yeah. Wow. That's an interesting, first of all, the story is so great. The way you tell it, I love your personality, your big smile. It's fantastic. When you talk about Girlfriends LA, when you talk about, having a 23-year, having to take over the family business, and all the things that went with it. So thank you very much for sharing this. And I can totally see how totally made sense. Like you had this passion to go to school, you ended up fulfilling that desire. And then, you go in something which is estate planning, which is very similar in a sense, like, as you said, to running a business, for somebody to run a business. And you did it very successfully in the corporate world, which is pretty awesome. So I would like to end, I'll tell you how I like to end my shows. I have a list of 30 questions, and they're all numbered 1 through 30. And I would love for you to pick a number, any number, and I will ask you that question. This is a sort of back of the card type of questions.
Okay, 20.
All right, 20. If you had a year off with pay, what would you do?
I work a lot, and I'm a workaholic, and I work a lot. I think I might sleep for a long time.
Beautiful.
And then I don't know, but maybe try to. I don't really have a passion outside of work because I work so much. So maybe I would sleep and then find my passion.
Okay, beautiful. That's a great answer. So rest is definitely part of the year sabbatical, and then some soul searching.
And just to throw into that, after we sold Girlfriends LA, I really kind of had that. I had gotten a big paycheck and I wasn't working. And what did I do? I went to law school.
Yeah.
So I'm not that good. I that's why I need to sleep, because I'm not that good at relaxing.
That is beautiful. Thank you so much for joining the show. It's been such a pleasure to have you. Before I let you go, any of our audience that needs to get a hold of you, what is the best way, somebody who needs your services, we are going to have in the show notes, everybody, you can find all the contact information for Kim. But Kim, for somebody that's just listening to the podcast on Spotify, how can they get a hold of you?
So I do want to throw one more thing out there. My
absolutely.
Practice is purely virtual. Great. Although I'm a California-based attorney and all my clients are in California, but I recently moved out of the state. Okay. So the easy thing is you can always find me virtually, but in-person meetings don't really happen. The easiest way to reach me is through my website, which is, or my email address, which is Kim@KimMillmanLaw, which is KIM@KIMMILLMANLAW.com. And my phone number is 818-340-5765.
Wonderful. Thank you so much for being in the show. It's been a pleasure to have you. I feel like I'm going to ask you to come back at some point. So
happy to do so.
Thank you so much. Bye, everybody. Thank you so much for joining the show. We will see you in the next episode.